All agreements are contract if they are entered into by competent parties with free consent for a lawful consideration and lawful object, and not hereby declared to be void. Now, what is being said? See, those agreements which are entered into by competent parties for lawful consideration, for lawful object, with free consent, and not hereby expressly declared void, they will become contract. They will become contract. They will become contract. The agreement is the first criteria. Competent party is the second criteria. Free consent is the third criteria. Lawful consideration is fourth. Lawful object is fifth. And not hereby expressly declared void is sixth. So six-fold hurdles are there in formation of a contract. Now see, there are two kinds of studies. One may be very simple, general, which is generally available everywhere. But if you want to raise your level, it does not stop here. These six criteria will not make an agreement contract, I must tell you. There are further more criteria. Oh, what are they? So if I ask you a question, see, batao, you tell me, I give you an offer to have dinner with me today, a sumptuous dinner. I am inviting you for a dinner and I will order from Bukhara, Dal Bukhara. And many other dishes. You agree that yes, I will come. It's a privilege that the teacher has asked me for a dinner tonight. I have ordered everything, very costly food of Bukhara, but you do not appear. Agitated, irritated, annoyed. Can I file a suit against you? You answer me. No. 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 Why? Because this is not a contract. Now you may raise a question, why it is not a contract? So I must tell you, my dear friend, at the outset, this is not a contract for the simple reason that there is no intention to enter into legal relationship. There is no intention to enter into legal relationship. Is it a necessity in formation of contract? Yes. Otherwise, what will be the difference between many promises which are made to be broken? Vachanam kim daridrata. You speak too much, but you do not perform. मैं तुम्हारे लिए चांद ला दूंगा, मैं तुम्हारे लिए तारे ला दूंगा. Can you do it? But can you be sued for such kind of promises? The answer is no. Because everybody knows ये कोई contract नहीं है. This is not a contract. There is no intention to enter into legal relationships. So this is seventh criteria, my dear friend. The eighth, not only this, many contracts have formalities too. Eighth, formalities, legal formalities. It may be required to be in writing. Can you have a contract to sell immovable property of rupees 100 or more if it is not in writing, if it is not registered? No, it has to be in written, it has to be registered. So formalities आ गई. Legal formalities. Section 25 of Indian Contract Act. You see Section 25 subsection 1 also, where there is an agreement out of natural love and affection. but it has to be written and it has to be registered. Then only it will be enforced by law. Otherwise, out of natural love and affection, many people will say many things. You will promise to your son a Mercedes if he tops secondary examination. Or you may promise to your beloved Nolakha. So can it be considered a contract? Such kind of promises do not fructify into a contract, because there is no intention to enter into contract. And if it is so, it has to be now formalized. That is what section 25 says. If out of natural love and affection you have done between near relatives, you get it in writing and registered, then it can be considered a valid contract. What is the ninth one, sir? Read ambition material. Read ambition barrack. It should not be uncertain. Section 29. Uncertain things can never be considered a valid contract in law. You will sell your Mercedes car, Mr. Ranjan? Yes. But how much? Price is not there. So can there be valid sale? The answer is no. The answer is no. What is the 10th one, sir? There should be possibility of performance. If I cannot perform the contract, what is the utility of contract? If I teach you and if it doesn't reach you, what is the utility of teaching? So for what purpose you have a contract? So it should be capable of being performed. If it is not capable of being performed, there is no contract. So possibility of performance is the 10th criteria. I must sum up how agreement become contract. I said, first of all, it should be an agreement. That is, there should be offer and acceptance. There should be a promise with consideration. Then it should be by competent party, section 11 and 12. 11 and 12 of Indian Contract Act. Then it should be by free consent, 13 to 22. I must tell you, my dear friend, here that James Stephen made a mistake in writing section 10. What he did, he wrote free consent first and competency later on. But in organization, competency comes first and free consent comes later. Section 11, 12 is competency, 13 to 22 is free consent of the party. So Mr. Stephens, you might have consulted Mr. Ranjan. He did not. And that is why I remember Thomas Jefferson. Every generation is a nation. And this tendency of sanctimonious reverence of the yesteryear people is not good. Every generation has its own wisdom. So I was saying that first and foremost it should be an agreement. Agreement should be with the by competent parties, with free consent. Then there should be lawful consideration, then there should be lawful object. So see, agreement, competent parties, free consent, lawful consideration, lawful object. And not hereby expressly declared void. That is sixth. That is sixth. Intention to enter into legal relationship, that is seventh. Legal formalities, that is eighth. If legal formalities are not fulfilled, it will not be enforceable contract. It will be unenforceable. It should be certain. And then last but not the least, it should be possible to be performed. If these 10 criteria are fulfilled, then the agreement becomes contract. So what agreements are contract and what not? That should be clear in your mind, that when there is intention to enter into legal relationship, then it will be contract, otherwise it will not be contract. When it is with legal formalities certain, possible to be performed, then it is a contract. And obviously the 6 criteria which are mentioned there in section 10 has to be satisfied. Then it will become a valid contract. I hope at the outset you must have understood when agreements will become contract.